in that question and answer feature or in chat. Otherwise, we'll be going through a material today that's all going to be about probate and non-probate assets, kind of identifying what goes through probate in a more of a visual way for you to see. We also have a book that we've written about probate and trust settlement, so that'll also be sent out to anyone who registered. After today's webinar, some of those materials are going to go out over email. You do have an option right in that same email in a feedback form to register to have us reach out for an initial consultation. So how it works with our office, if any of today's topics kind of spur some questions in you that you need more specific advice for, or would like to discuss with an attorney from our office, we do offer 2-hour complimentary initial consultations where you can meet with an attorney either here, in Appleton, Green Bay, or Oshkosh, wherever works best for you, to discuss those things. So you do have that option if there are more in-depth questions you have or something that, makes you think you need to discuss them more specifically. Otherwise, jumping right into today's webinar, all about, again, April Fools, almost April 1st here for us, common myths and mistakes of probate. So I'd just like to start off with, what is probate? So probate is a court process for when someone passes away, the assets or things that they owned, and that can be their bank accounts, investment, retirement, things in their house or apartment, whatever it is when they pass away. So if those were assets in their name, they may need to then go through the probate process when they pass. Probate is not a bad process. It's just that it's important to understand that because it's a court process, it can take some time. It has some expenses associated with it, and it's also public. So just be aware that typically start to finish, most probates take about a year to a year and a half to complete. That's not because the personal representative, or you might be more familiar with the term executor, isn't doing their job. It's just that probate is going to feel a lot like this is the thing you have to go and do, that the court's telling you to go and do, publish this notice, send out these information, get these signatures, and then you wait for a court deadline to pass, and then you go and do the next thing that the court is telling you to do. So it's a lot of this idea of like, hurry up and wait. Probate can, as I said, because of that court involvement, create some additional expense. It is important to know that there are court filing fees, regular county fees based off of an inventory value. Typically, that personal representative will take like a 2% fee. And if you hire an attorney, it can certainly be more expensive from that. So you hear on average ranges of like 3 to 5% of someone's overall probate estate in terms of how much that probate is going to cost them. So I think now that we have just, again, that is very basic, this is what probate is. Now it's just, why would you, what goes through probate then? What uses that year to a year and a half process to make sure everything is settled? Wills. So I think that's, as I said, one of the biggest myths that we have is that if you have a will for your estate plan, that you won't need to go through probate. And wills, in their kind of simplest definitions, are a set of directions to the probate court. So wills don't avoid probate, they go through probate. That's how they work. So if you have a will, that doesn't mean that you'll avoid probate. It's not bad to go through probate. Again, it's a really important process because it makes sure your bills are paid, your final expenses are taken care of, and then things went according to your wishes. So it is really important if that's your plan, if that's the process that you're going to use. But again, wills don't avoid probate. They're intended to go through probate. Again, we've talked about why probate can typically get a bad reputation because of the time, expense, public nature of it. So there might be reasons why someone is trying to therefore avoid probate. And one of the really common things that they're trying to do is, get assets out. But there are really important reasons why I would say that someone should make sure that they are using a probate. One of the things would be that if you have young children and you need to nominate guardians in a will, it's really important that you have that will in place, and at least, if not the financials, at least have who you'd want to take over custody if you or you and your spouse had passed away. So if you have young children, having a will go through probate is really important. If you know that no matter what you do, your family just doesn't get along, there's going to be a lot of mess, there's going to be a lot of fighting. The nice part is that that court is kind of like that mediator who can right off the bat, this is how things are going to go, this is what you need to do, and they'll help to alleviate, hopefully, any of those fightings because it is a court. So if you know right away that things are going to be very confusing, things are going to be hard, a court could be a really good reason to use probate. If you have a deficit estate, which a deficit estate would be like your estate filing for bankruptcy, you owe more money than you have. That's a really important reason to use probate because in that year to a year and a half process, what's going on internally with the probate court is that they're trying to first, admit your will, or if you died intestate, then they're going to go ahead and approve the personal representative, also called executor. Then that person is going to go ahead and make sure bills and final expenses are paid. They're going to publish creditor notices. And what's important with those creditor notices in a deficit estate is that even if you don't have enough money to pay your expenses and your debts, well, the court is going to decide the order of priority for those creditors. So even if no money goes out to your beneficiaries because you owed more than you had, well, neither is your liabilities. So the court kind of sets that this is the final thing for creditors. No one's coming out of the woodworks years later. No one can kind of force your relatives then to pay any debts that you had because of that probate process. So it is really important then if you have big creditors or just really any creditors, especially a deficit estate, probate is a great place for you to want to be with your estate plan. There are also some long-term care planning options, and we're not going to talk too much about the elder law side of things today. But there are planning options that we do use in someone's will if they were to pass away and their spouse was to be like in a nursing home. There's specific planning often that we want to make sure is in that will. It's the only place we can do it. So that would be a really good reason to use probate as well. I would also like to talk a little bit about that role of personal representative, or you may be more familiar with the term executor. Typically, if someone was helping, say, a parent during their lifetime, they may be what's called a power of attorney, where that's the document that shows that they can pay bills for their parents, they can help to manage healthcare decisions, all those sorts of things. Powers of attorney end when someone has passed away. So if someone was paying their parents' bills using a power of attorney and then they pass, that power of attorney is no longer, working. That person has passed. If you have a will, or if you don't have any estate planning at all and then need to use probate, it is important to know that all of the interested parties are going to have to be served with a probate. So that means that before the personal representative that you would nominate or executor is nominated, they have to serve all of the interested parties. If they can get everyone's consent through signed waivers, then they can typically be approved right away as soon as all the interested parties consent. If not all the interested parties consent, which is oftentimes either really difficult to do or people just aren't willing to sign off on that, it typically takes at least 30 days before that personal representative is approved by the court, given what are called domiciliary letters, and can now pay bills. So there can be typically about a 30-day delay in paying bills when you use a probate for your estate plan. That sounds really scary. It doesn't need to be. Creditors understand that they will have time to come forward, they will be paid. But until the court has actually approved who that personal representative is going to be, no one has access to those accounts. So they will be paid, your funerals and other final expenses will be paid for. If your personal representative has paid that in the meantime, personally, rather than through your estate, they will get reimbursed. So there are lots of options for that too. But there is court approval of that personal representative is the big piece you want to know there. Plus, I want to highlight again that service to interested parties. So an interested person might be someone who is inheriting under your will, or someone who would have inherited under a previous version of the will, or if you died intestate. So say, for example, that you are a single parent with 3 kids, and for, as is your right, you decide to disinherit, we'll say, one of them. And that's fine, you can do that. But that child who's disinherited is still going to have to receive notice of this probate action. And they would have to consent to the personal representative and the will in order for it to be approved, before it would be approved with a hearing. So that hearing just is a chance for anyone to come forward and say if they object. Most of the time, people don't actually come and object. It's just that they aren't necessarily willing to sign off either. So that can cause that 30-day delay, which again, everything will be paid for. It's just that is the probate process from the point the will is actually submitted, or if you had passed and didn't have a will. I'll pause for questions on that, just because I understand that starting a probate, how people are going to get notice, how a personal representative is going to get approved is a really common thing that often people have questions on. So I'll pause for that. Okay. Otherwise, I want to talk a little bit about what assets would actually go through probate. So it is true that beneficiary designations avoid probate. So for example, if that bank account was in mom's name and it had a pay on death to one child, though that bank account wouldn't need to go through probate if that child was there to receive it. So what that means, though, is that those funds that went by beneficiary designation, they just go right out to that person. So if the bank account says, pay this to my one child, that child would present a death certificate and then they can receive those funds. That sounds easier compared to that 30-day kind of delay that happens with probate. But it just depends on what someone's plan is. Because if you have more than one child, or say more than one beneficiary, you have to be careful with how all of your assets are coordinated and what those beneficiary designations are. You can run into a lot of issues with bill paying if your entire plan is based on beneficiary designations. So beneficiary designations are really excellent tools. We use them all the time. You just have to make sure that they're coordinated with what you're doing, because if everything just went by beneficiary designation, then there's no money in your estate to firstly pay your bills, your final expenses, and your taxes for that year. So if money all goes out, kind of like you skip probate and it just distributes out to those people, that can be really difficult to actually have family or beneficiaries settle up and make sure bills and final expenses are paid. If instead of dispersing it at the outset, so if you had multiple kids, instead of saying, a third on each account on everything, and you just left it firstly to one person with the intention that then they would follow what you had wanted in the will, that's also a problem, because once the money is moved into their name, it's just theirs. So they don't have to follow what you would have wanted in their will if they were in your will, if they receive it by beneficiary designation. So, and you might think that never happens, but unfortunately I have a client that came in specifically because that happened in their family. It was a blended family, and one child had received everything and then didn't share with their siblings, because there's no legal obligation for them to share. So they could just kind of take the money and run. The other thing, though, is that what you're asking that person to do once they just receive the account by beneficiary designation and then disperse it is make a gift, because there is no legal obligation to do that. And there can be reasons why someone can't gift. If they are going through a divorce, or if they are being sued, filing for bankruptcy, they're on certain benefits, or their spouse is on certain benefits, like receiving care in a nursing home. Or, can create tax problems for that person with those gift tax or estate taxes. So there can be a lot of legal reasons why that person can't then gift the funds. So while probate does take, a little bit of time to complete, you're not unable to pay bills or disperse money for that entire year to a year and a half. It just typically takes about a month to get approved to be able to pay bills and final expenses, and you can start to distribute funds from there. So the 30 days sounds scary. It's not. Beneficiary designations are very powerful tools, but if your plan is your will, you would actually want to make sure things go through probate. If they go by beneficiary designation, then they avoid probate. So if that bank account, instead of a pay on death to a person or persons, said pay to my estate, that would send it through probate. Or if that bank account didn't have a beneficiary designation, as is, sometimes common, that assets just don't have a pay on death, a transfer on death, a beneficiary, then it would have to go through probate if it doesn't have somewhere to send it to. So assets can also get through probate just by not having any beneficiary designations to begin with. The only accounts that typically aren't a good idea for tax purposes to go through probate would be retirement accounts because of the Secure Act. We have a 10-year, with very few exceptions, 10-year payout on retirement accounts. If it pays through to an entity like an estate, that can force a 5-year payout. So it's really about what we're trying to do is coordinate certain assets to the process that we're trying to use. And a lot of times, we might use probate or wills to do that, or we might instead start to talk about things that have lots of the same planning as probate, but don't have to go through probate. And that's just that's a trust. So a lot of times you hear differences between wills and trust. Wills have those same set of directions. It's just the process that they use is probate. Trusts can have those exact same set of directions, but they're a private administration. So because trusts don't have to go through the court process, they typically take, on average, more like 6 to 8 months to complete. Now, trusts do cost more to create. They're much more work to create with an attorney at the outset, but they typically are less expensive than a probate would be. So where you hear the averages of 3 to 5% on a probate, you'll typically hear, 1% or a little under 1% for a trust administration. If you hire a professional trustee, you're typically more like 2% is what I've seen. But that is still ultimately oftentimes less expensive than what a probate cost would be. It is also private, and it can be private amongst beneficiaries. So if the trust is structured so that way the only people who receive information on it are the people who are actually receiving something, you can limit information across beneficiaries as well. With the probate process, again, all that information is public. So someone could go in and request a copy of your will. Everyone who's an interested party is entitled to a copy of it pretty much right at the beginning to approve the personal representative. So they could see exactly how you left things, any specific directions that you had. Depending on, especially disinheriting someone is probably better done through a trust if you have concerns. If you just have a really large family, that could be a reason as well. So for example, if you're a single person, you're never married, never had any kids, but you have like 13 siblings, well, your heirs at law are considered those 13 siblings. So even if you were really nice and left everything to your nieces and nephews or to a charity, your 13 siblings are still going to receive notice of the probate. With a trust administration, you can word it so that way the only people who have to receive any information are the people who are actually receiving something. So it can really help if you're a private person, but also just understanding who would need to receive those services and sign off on a probate. I think a lot of families are really surprised by who has to receive notice with a probate. I've had a family that I helped with before. They're like, why do all these half siblings and things need to receive notice? And if a sibling is passed, why do their kids have to receive notice? And that's just with probate defining who are your heirs at law. And that's a statutorily defined thing. You have to give notice to those people. It doesn't mean they're going to object. It doesn't mean that you're not going to be able to pay bills and have the will followed. But probate is kind of I'll use the word antiquated. I don't mean it disrespectfully, but just to say that, especially with large families or modern or blended families, you just want to be aware of who has to receive information in a probate. And once that initial 30 days is done, the personal representative has been approved. If they're not receiving anything, they're not going to receive any more notice. But just at the outset, that is something that happens. So let's see. If there are any other questions, you can feel free to ask. I'm just thinking about what I haven't covered in my head for a second. So, okay. I think those are all kind of the big misconception or big myths and common mistakes with probate, understanding the timeliness that powers of attorney end, how that approval process works, its differences with accounts that go by beneficiary designation, and its differences with trusts. So either I nailed it, or maybe everyone's just taking in all this good probate information. Again, we're gonna send a handout visually showing you what assets would go through probate, what assets would avoid probate, and a book about probate and trust settlement. If you like to read materials, if you have more in-depth questions or maybe want to talk specifically with your situation, again, we do offer those 2-hour complimentary initial consultations where you can meet with an attorney from our office. They're no charge. If you just want to, ask good questions, and it's up to you if you decide to implement the planning that we recommend. Otherwise, next week, we're actually going to be talking about at our webinar next week, estate planning strategies to minimize estate taxes and administrative fees. So if you have tax specific questions, you want to know more about the fees associated with the probate, with the trust administration, that is a good webinar to attend for those questions. Otherwise, we do also have, we call it our Wills versus Trust public seminar. We do that once a month. We rotate between Appleton, Oshkosh, and Green Bay. And on April 10th, we will be doing that Wills versus Trust seminar at the Culver Family Welcome Center. So there's a 2 p.m. and a 6 p.m. So we'll talk through powers of attorneys, more about wills, the probate process, trusts and their process, and a little bit on long-term care planning. There is 2 sessions for that, a 2 p.m. and a 6 p.m. For that event, you do need to register. You can go online to estateplanninglive.com or on our website to register for those events. And then otherwise, we have the webinars every other week too. All of those events are listed right on our website. And again, you can go to estateplanninglive.com to see that full list of events and register for any sessions. So otherwise, without any questions, I won't keep you guys too much longer. Thank you very much for your time. I hope you have I know it's going to be cold this week, cold and rainy, but I think spring is in the air, and so is April. So thank you for joining our April Fool's session with probate.